Let me just welcome everybody, UT faculty, distinguished guests for joining us from wherever you are at whatever time around the globe. We're here today to hear Laura Petersen present a paper about an ethos of restitution. And the paper, as you know, is the winner of the Zipporah Wiseman Award for Scholarship in Law, Literature, and Justice. Zipporah, of course, was our dearly loved colleague. There will be a separate memorial for Zipporah on January the 21st at 3 p.m., I believe, and there will be a separate announcement about that. So let me keep my remarks anyway about Zipporah very short in this particular forum. I think all I will say is that personally, I remember Zipporah very, very fondly. She was actually one of the very first persons to welcome me when I arrived here, a young Israeli man out, right out of the prairies of northern Massachusetts, landing here in Austin, Texas. And Zipporah welcomed me in a very characteristic way, very warmly, but also with a very Zipporah non-nonsense approach, which I loved. It was exactly the right thing. Okay, so also, as you know, many of Zipporah's friends and admirers came together to create the Zipporah Wiseman Prize, and Laura Petersen and her paper are the first winners of the prize, and the prize is being administered, ran by the Rappaport Center. So very aptly, our agenda for today will be as follows. We'll hear from Fred Wiseman, a few opening remarks. We'll hear Laura present her paper. We'll get a short commentary from Sandy, and after that, Sandy Levinson, that is. And after that, we will open up for discussion and Q&A. But before all of that, let me invite Karen Engel, who's the director of the Rappaport Center, to give a few opening remarks and maybe present the speakers.
All right, thank you so much, Oren. And as Oren noted, we will have that memorial in January to celebrate the many contributions that Zipporah made to UT Law School as well as to legal education more generally. But today we get a glimpse into one of her passions by discussing a paper that I feel quite certain she would have loved. Among Zipporah's many interests, she was keenly attuned to the ways that texts, and a variety of texts, whether legal cases, and I'm sure, Laura, she would have happily added glosses on them, fiction, poetry, or film, actively construct and define our perspectives on justice. And as a part of that interest, she was one of the early people to edit a collection on law, literature. It was also on feminism, and she did that with UT English professor Susan Sage Heinzelman. And as you all know, Zipporah also loved bringing people together. And so I think the best way to say something about this prize is to thank the many people who made this event possible today. So first of all, the over 50 people who generously donated to establish the Zipporah B. Wiseman Prize for Scholarship on Law, Literature, and Justice are responsible for us being here. And that includes the many UT colleagues who first came together to find a way to honor Zipporah, and the many more past and present UT colleagues who joined in, but also colleagues and friends of Zipporah's from many other institutions where she has taught. And it's nice to see some of you here today. And of course, it also includes her husband, Fred Wiseman, who we'll hear from, and her two sons, David and Eric. And I know David is with us, so good to see you. In addition, the event was also made possible by the many professors, as there's some overlap here, of both law and literature around the world, who distributed the information about the prize to their students and colleagues. The students, like Laura Petersen, who wrote papers and submitted them. This year's judges for the competition, and we had a local committee of 3 judges who narrowed the papers, the pool, to 3, and then sent it on to an external committee of judges. So that was 6 judges in all. Sabrina Barton at the Rappaport Center, who coordinated the competition. the student editors who worked to publish the paper in the Rappaport Center Working Paper Series, the UT Law Faculty Colloquium Committee, which Oren chairs, read the paper and thought it would be great to work with us to put together this special colloquium. And then Beth Kells, who works with them and who is here, created the lovely poster that was sent around. So it takes a village, and I feel confident the Zipporah would be quite impressed and happy, if a little surprised, to see this village from around the country come together for this endeavor. And she would insist that I thank you profusely, which it is my pleasure to do. We're also quite honored and delighted that Fred Wiseman has agreed to offer some opening remarks. Now, most of you might know Fred as Zipporah's husband of 65 years. You might also have heard that he's the finest and most prolific documentarian of American institutional life. And if you know that he and Zipporah met in law school, then you also know he has a law degree. Any one of those would be a reason to hear from him today, but of course, all three make it particularly special. So I think I'll say thank you, Fred, for joining us, and ask you to make your remarks before I briefly introduce Laura.
Well, thank you. I'm glad to participate with you today, and I'm very pleased that the prize has been set up in Zipporah's name, and so many of you have contributed, which it makes it possible to give these prizes. Zipporah, how can I put it delicately? Zipporah had a very good bullshit meter, and whether it operated in all respects. Whether when she read, she could immediately, she really immediately knew whether writing was phony or not. Similarly, when she met people or went to faculty meetings at either Northeastern or UT, she would come home and do wonderful imitations for me of some of the pretentious remarks and comments that she heard. So the idea of setting up a writing prize in her name is an honor for her and for us in the family. And I very much enjoyed reading Laura's paper because I understood it. It was written in English and in the kind of clear, plain, direct language that Zipporah used and admired in the work of others. So I'm very happy to be with you today to give this short introduction on behalf of our sons, David and Eric, and our grandchildren. And we appreciate all of you who've contributed to the prize and all of you who submitted papers. And I'm hoping the prize will continue for a long time, continue to be awarded for a long time, and that the papers will always be in the spirit that Zipporah represented. Thanks.
So Karen, is it me or you? I don't know.
I was trying to unmute myself.
Here you go.
Thank you, Fred. So very brief introduction of Laura Petersen, since you all got information on her. Something that was not in the information is that she just a few days ago submitted her dissertation for her PhD at the Melbourne Law School in the Institute for International Law and the Humanities. And the title of her dissertation is Making Good Again, Law, Aesthetics, and Responsibility. And the paper that she'll discuss today is the first chapter of that dissertation. The paper is entitled An Ethos of Restitution, Walter Schwarz and the Gloss, and it reflects many of her interests by considering the legal, literary, and artistic practices of restitution in post-Holocaust Germany. Also, I'll just mention that Laura serves as the Vice President of the Law, Literature, and Humanities Association of Australasia. So I know that she will help us send word of this prize throughout at least that region. After she speaks, as Warren mentioned, our UT Law School colleague, Professor Sandy Levinson will respond. Sandy shares Zipporah's passion for law and literature and has also done considerable work in the field, and he was instrumental in helping us set up this prize. So take it away, Laura.
Thank you so much for the incredibly warm welcome this morning. I feel so lucky to be here. So I'm zooming in from my house in Melbourne. And I'd actually like to acknowledge the Indigenous Wurundjeri people who are the traditional custodians of the land where I'm sitting. But before I begin the talk, I just have to say I feel immensely honoured to be here and to have been awarded this prize. All the effort that has gone into making it a reality suggests that Professor Wiseman was an incredibly special person in a lot of different ways to different people. And so I feel incredibly honoured to be the first recipient of the prize. So thank you so much to Karen Engel, especially, and everyone at the Rappaport Centre. And I'd like to echo her thanks to everyone involved in the prize. But also thank you, Oren, for organising the session today, as well as Fred and Sandy for speaking as well. And so thanks for coming too. So I feel like it's just a glowing reflection on her and her scholarship and her way of being in the world that so many people have given up their time and effort to remember her in this way. So it's obvious to me that this prize is an incredibly special thing and it remembers an incredibly special person. So, but I also wanted to acknowledge where I'm sitting today because today's talk ranges across times and across places. And it's with a group of people who are all in different time zones and in different places. So putting together this talk for today has made me think about sort of constellations and connections which are visible, but also invisible and can take place through the practices of scholarship and through reading, and also in institutions of law and institutions of research. So because I can't ever now meet Professor Wiseman, and I don't actually feel it's appropriate to call her Zipporah, so I'll call her Professor Wiseman. I can only encounter her now through texts and through stories about her. So through what others say and tell, but also, and most importantly, perhaps what she's written herself. So I found an old text of hers, which was published in the New Republic from 1999. And in this text, she reflects upon visiting Israel when she was 19 years old, so back in 1949. And this was incredibly curious to me because the central protagonist of my paper, which I entered in this competition, is a man called Dr. Walter Schwarz. And Schwarz was also in Israel in 1949. Schwarz was from Germany, however, and Professor Wiseman, as I understand it, at that time was from Canada. So who knows if they crossed paths back then in Israel? It's impossible to know. But the circumstances of this prize mean that they've been brought into a constellation together now through me sitting here in Australia. And it all started through my visit to the city library, the Stadtbibliothek, which is in the area of Mitte in Berlin, in Germany. So I'd like to begin my talk today at that library in Berlin. So I'd like to start with the Institution of Research. So the day I went to the library, there was an exhibition open in a small room in sort of the older part of the library complex there in Mitte. And the exhibition was entitled NS Raubgut, which means National Socialist Stolen Goods. So I'll just share my screen now and show you a picture of this exhibition, which is on the PowerPoint. So this is an exhibition, but it's in a really small and quite elegant room. And the exhibition replicated a home library. So there were all these bookcases on different levels, and they were crammed full of old books. So these were books that had belonged to Jewish families or other organizations during the Nazi period. And the exhibition was part of an ongoing restitution program to identify the provenance of these books in the collection, but also then try to find these original owners and give the books back. So I was fascinated by this process because I was writing my PhD at the Melbourne Law School, and the topic of that dissertation had shifted. I'd started to become interested in the German processes of restitution after the Holocaust. And the reason I was in this library was to access a specific and very obscure German law journal. The journal's called Rechtsprechungs- und Wiedergutmachungsrecht, so the Decisions of Restitution Law Journal, and it started to be published in the 1950s in Berlin. So I was keen to see what was written in this journal. But before I could even read the journal and to even enter the Stadtbibliothek, so to enter the library, you need to cross the threshold. And I deliberately linger on this door to the library in Berlin in my paper, but just generally, because I feel like it's a unique piece of art that also comments on its form. So it's opening, it's a portal that also makes a statement about the threshold. So this is the A Portal artwork by Fritz Kuhn, and you can see the red sign Ausgang means exit, and there are two little vertical brass handles below. And we go in on the right-hand side in the Eingang, the entry, where there are also the two little brass handles. So this is a big portal with the two doors kind of integrated into it, with 117 metal squares, and each one contains a variation on the letter A. So each letter is presented in a different typescript. So the area of this library, Mitte, was in the former east of Berlin, and Kuhn was a well-known East German artist. So he had also completed the top of the Bell Tower Memorial at Buchenwald. So this artwork for me, sort of a reminder of the role of text as a portal. So it's a liminal space between the inside and the outside on the threshold. So again, let's hold on to this idea of the text as a portal. So a way to encounter people through their words, through time, and in specific places. But let's go back in time now and change gears and go back to a legal institution as well. So legal decisions and case law are other ways to encounter people through words, and they write, as Karen mentioned in terms of Professor Wiseman's work, they write certain histories within their forms. So I'm going to now start talking about a German case, one which I found out about through walking through this door and being in this library, reading this specific journal called the Decisions of Restitution Law Journal. So this is a case. This is a restitution law case. The citation's at the top of the slide. It's a case set in the middle of World War II in the spring of 1942. So a Jewish mother in Poland succeeds in saving her children by entrusting them under false names and false papers to the care of a Polish farmer. The children at the time were aged 4 and 12. So it was a poor farmyard and the children couldn't sleep overnight in the house. So they slept outside under a few wooden boards. In the 1960s in Germany, the department in charge of restitution payments denied payment of compensation to the children. They were now adults, on the grounds that they didn't meet the requirements of the restitution legislation, specifically that they didn't live under inhumane conditions. This was because, reads the judgment of the court, the siblings were able to stay together, they could move about occasionally in the farmyard, and the farmer shared her meagre rations of bread with them when she could. The claimants appealed. The restitution department fought this case through 2 instances until the Bundesgerichtshof, so the federal court, Germany's highest court apart from the federal constitutional court. The Bundesgerichtshof sent the case back to the first instance to be reheard in 1967. So summaries of these types of decisions were collected at the time in this journal called the Decisions of Restitution Law Journal. And this is the journal I'd come to find in the library. And it turned out to be a sort of practitioner newsletter. It had case summaries, and there was occasionally a commentary from lawyers and people involved in the restitution process regarding certain points of law. So this is an example of one of the tables of contents. And I want to draw your attention to the section which I have highlighted, which is the glossen. So you can see here, interpolated sort of into the right-hand top of one of the pages in the journal. So in this sort of milieu of very straight black letter German law, there's started to appear in the journal a genre of commentary called the gloss. So they were italicized, and even more strikingly, they're printed under a pseudonym. So here you can see at the end of the gloss, I've italicized the name, Socialist. So I'm going to quote now and show you some slides from this gloss. It's titled Im Blätterverschlag, which I translated to mean in a shabby shed. And the gloss was printed in this journal in response to the case that I was just talking about. So the gloss says, one asks oneself, why in the world was it necessary to drag this case through 3 instances? The men and women who played their part in denying their claim were once children and perhaps have their own children. Is it then so incredibly hard sitting at your desk to imagine how it was for these children who were locked out of the house at night like vagrants and dogs and had to sleep alone at night in a shabby shed? How on earth is it possible, after all which has befallen the German nation, people in this country seriously believe, maintain, and put down on paper that this existence was humane? It is possible, and depressingly, one must conclude, nothing that happens to you, no experience, no misfortune is able to rip down the shabby shed partitions that surround blunted hearts. The author, Socialist, is obviously a pseudonym in German. So leafing through the dusty and the heavily bound copies of this journal, I was struck by these glosses, their strident language, their argumentative rhetorical tone, and most of all their form, the gloss. So the gloss is a genre of commentary which has a legal history extending back to the glossatus in medieval times. But the gloss is also a genre which has a strong German literary and philosophical history. So it was famously used by satirists in German newspaper feuilletons like Karl Kraus, but also by literary and philosophical greats such as Theodor Adorno. So these glosses, it seemed to me, were another way of undertaking restitution, one that works literally adjacent to and alongside the legal process. So they're different attempts, but they're on the same page, conceptually and also so spatially in the journal. So I discovered there are over 130 glosses printed in this journal. Some of them were distinctly literary in style, so they were in the form of a fairy tale or a poem, whilst others are more direct, and they always had this kind of punchy last line. So the gloss became, in this journal, is a hybrid form that melds kind of elements of legal tradition with literary style. And the fact that the author used a pseudonym, Socialist, also really intrigued me. Finally, as you can see, the glosses are separated from the main text through a black line, and they're formatted in italics. I draw your attention to this because the choice of typesetting in Germany for a legal journal in the 1950s is a significant one. I also want to draw your attention to this because it's part of the material technologies of how we know and read law. It's always through these material forms and their permutations. So today, for instance, I've chosen a specific font for the headings of my PowerPoints. This is Futura. And Futura was a font designed by a German typographer called Paul Renner. And Futura was designed specifically as a rejection of the Fraktur script, which you would know, that's the kind of black letter font that is synonymous with the Nazi regime. And because of he created Futura, Renner was arrested by the Gestapo, but he was ultimately released. So my point is that form and their material permutations really matter. But let's talk about the author of the glosses now. So after some research, I found out that the author was actually a German Jewish lawyer called Dr. Walter Schwarz. So born in 1906 in Berlin, Schwarz became a lawyer in Germany. He managed to escape Germany under Nazi rule and went to Haifa. He volunteered for the British Army and overheard German radio transmissions in North Africa during World War II. But after the war, Schwarz returned to Israel. And so he was there in 1949 at the same time as Professor Wiseman. But then Schwarz moved in the 1950s to Berlin, and he ran a successful restitution law practice where he assisted the victims of persecution in making their compensation claims. But Schwarz, of course, was different to most of the other lawyers that were practicing at that time in Berlin. He was Jewish. And so it is my suggestion that Schwarz uses the pseudonym to write these glosses as a strategic cover. Schwarz writes the glosses under two pseudonyms. He uses Sagittarius and Sabidus Steinblech. So it's clear that the subject matter of these glosses is often controversial, and it pushes particular and possibly quite unpopular points of view. And using the pseudonym means that Schwarz can critique the institutions and the parties to the restitution process. So the legislature, the bureaucracy, and in a couple of the glosses, even the conduct of some of the victims making the claims. So he relies on these people for his income, but he also has a significant kind of working and social relationships with everyone who is involved in the process. So I can understand why Schwarz felt he could only offer this account of restitution, which promotes a certain form of conduct and ethos. I can understand why he felt like he could only do this through taking on the persona of the glossator and a pseudonym. So the persona is a mask which enables Schwarz to actually write. Let's have a quick look at some of the other glosses which I found that day in the Berlin Library. Apart from the glosses in the style of a case note, like in a shabby shed, which I just discussed, there were other glosses which focus on the conduct of the bureaucracy in conducting the restitution program, and also the language of the courts. So for instance, in the gloss titled Concerning the Climate, he reflects upon how the conduct between the applicants and the department creates the atmosphere for the proper conduct of restitution. And I quote, "But laws one can create, climate one cannot. It has to emerge. The ground out of which it can blossom is human behaviour." So he uses the form of a gloss to call for a certain attitude on both sides towards legal appeals, as, quote, "The point of restitution is not a tournament, but a joint struggle for justice." Connected to Schwarz's statements regarding conduct is a broader issue concerning the laborious process of lodging the applications for restitution at that time. So he notes there are 30 to 40 files for the average kind of individual restitution claim. And then the real game begins, as he says, as the files become shuffled and handed around the departments. So he's critical of this circulation of paper, and particularly the effacement of the human dimension through all of this process. So he writes, quote, "Does it have to be said again and again that this paper decides the fate of people? Should really this last chapter of restitution fall victim to helplessness and bureaucratic lethargy?" And as I mentioned, Schwarz is also acutely sensitive to the language that's used in the restitution court processes.
My thing's on. Team Samsung, what's up? It's laundry time. Oh, hold on. These clothes aren't.
So in 1968, he mocks the excessively kind of complicated legal sentences that are delivered by the court in the aptly named gloss entitled Juristic Baroque. So after quoting a complicated statement from the court, He finishes with the short, so sarcastic line, "There is nothing like a language of the judge that is close to the people." So just to finish up this section on the glosses, I'd just like to note, primarily the glosses are a vehicle for his rhetorical commentary, but he often takes this further, and he describes kind of the process of restitution now as a tragedy. An important part of a tragedy is catharsis. So here, this is a gloss called The Deluge. And I think it's really interesting to think about how he brings in this image of the bombed streets of Berlin that would be outside his window when he's writing this legal commentary. So one thing above everything else should never be forgotten. The brown deluge of devastation was immeasurable. Immeasurable is also the field of rubble which it has left behind. It is good this image of the horror of this generation stands in front of the eyes of those to which the burden, as well as the good fortune of catharsis, has fallen. So in the paper, I argue that Schwarz's collection of glosses is a unique record of the relations between institutions and the different actors in the restitution law process over this period. So one which captures but also critiques the process of this law. So I conclude that Schwarz's choice of genre of the gloss means that a change in words, in tone, and in focus away from kind of a neutral mode of legal argumentation means that he uses the genre of the gloss to try to make others pay attention to the material effects of form and language in the experience of practice of law. So Schwarz's glosses are designed as commentary, but also reform. And so it is my argument that his practice of glossarial writing offers an ethos of restitution in form as well as in content. But Schwarz's glosses have never been written about at all, except as minor footnotes in obscure German legal histories. He did publish a selection of them in a book in 1969, which he titled Spoken into the Wind. And so you can see by his choice of title that he's wondering what sort of effect these glosses may have even had. But Schwarz himself writes in the introduction to the book that it was important to publish it because in this way, he could bring the activity and his critique of restitution to other audiences. So he uses the form of a gloss as a portal, so a door, a way to look into a sphere of state activity, which is conducted by practically shutting out the public, even though it dealt with one of the murkiest chapters of German history. So this area of restitution law in Germany and internationally was sort of scarcely paid attention to at the time of these decisions. And I would argue it still remains a significantly under-researched area today. So this paper that I submitted to the prize competition and is chapter 1 of my thesis, this is the first time that I'm aware of that these glosses have ever been translated into English. And so to conclude and to now bring everything together, there was a thread running through my talk today about how I can only encounter people through their writing, how Professor Wiseman and Dr. Schwarz can only be now known to me through stories and through their texts. But what was fascinating to me, and I don't mean to be presumptuous here, and I know Karen mentioned this text in her introduction, but what seemed to emerge from my readings was that I noticed that both Professor Wiseman and Dr. Schwarz shared similar concerns in this text around this genre of legal writing and why it matters. So for instance, in the preface to this book, Representing Women, she writes with Susan Heinzelmann, interdisciplinarity requires that the stories about how people live their lives are no longer kept separate within the confines of discipline-specific formations like law and literature. And so Schwarz's glosses seem to me to also be another way of performing this interdisciplinarity. So I doubt that Professor Wiseman and Walter Schwarz did cross paths in Israel in 1949, but they could have. I mean, it doesn't really matter. What matters is that they both seem to realize how you write things and the form you use, these confines of law or literature as disciplines, they can't hold everyone's stories. So law and literature do different things, but they can also do parallel and interdisciplinary things too. And they can also be on the threshold. They can work as a portal. They can be one of those sorts of doors. And on top of this, I'd like to add that the how matters too. Practice matters, the how you do what you do, the where you do it, the materials that you use, perhaps even the fonts that you choose. And so it seems to me, as an outsider, only able to be now a reader and a translator, encountering both Professor Wiseman and Dr. Schwarz through their texts, it seems to me that they both deeply understood this, and they both work to tell other stories in a way which recognize the complexity of storytelling, both in and outside of and between different forms. So finally, this talk and my paper were both about people in places, the way they write and the texts that they leave behind. Today, I was trying to think further about how we encounter them, our practices and how we do our work, and the institutions like the library in which we do our research. My point is to recognise that our ways of speaking and writing the law change what we can say through the law. It is to recognise the forms we use and how we conduct ourselves when we are writers and readers matter. And sitting here today, speaking to you all through the ether, it seems to me that this is something which transcends and brings together all different types of constellations of times, of places, and of people. So thank you so much. Thank you for listening to me today, but most importantly, thank you so much for this wonderful prize.
So I good, okay.
Yeah, Sandy, you go next.
Good.
Thank you.
Yeah. And let me put the clock on so that I hope I will stop at 10 minutes or so. I think this is the third time I've read the paper. The first couple of times, as Karen suggested, I was part of the screening committee. So the first time I read it, I skimmed it and knew that I liked it a lot. The second time was to try to decide which, I think, of the 4 or 5 papers would go on to the real selection committee. And I read it somewhat more carefully and recalled that I thought it was the most interesting of the 15 or so papers that I had read, in part because, although I don't know if this occurred to me at the time, I think it's relevant to my comments today, that I do find it somewhat Kafkaesque. And in that sense, I thought it was the most gripping and interesting of the papers in terms of creating a certain mood. And then I read it more carefully, obviously, for these comments. So I want to say 2 things, 2 major things. The first is, frankly, that I'd like to know more about Dr. Schwarz on, for example, why did he come back to Germany? That was certainly not a kind of innocent decision in the 1950s. And if he went to Israel or Palestine, then I'm curious if that was because he had been an ardent Zionist. And if he had been an ardent Zionist, that would cut against his returning, especially to Germany. So I just find that part of what makes him interesting and mysterious as a character in this story. It also struck me on the third reading that there is something quite Talmudic about this mode of writing glosses, that even if, as I suspect, he was a secular Jew rather than an Orthodox Jew, it would be somewhat surprising if he were completely unfamiliar with the Talmud as a form. And as I'm sure most, if not all of you know, the way the Talmud is structured is that the central text is in the middle of the page. And then there are glosses to the side of it. And then, of course, one of the interesting questions is, can you continue that tradition, or is it a closed tradition with regard to the glossators of the medieval period? But in any event, the Talmud is certainly the most famous glossed text that at least I'm familiar with in terms not only of commentary. There are obviously libraries of commentary on Plato and Aristotle, etc. But this particular form of commentary might, in some sense, have been peculiarly attractive to him. But then it occurred to me that he had the power to write this gloss kind of semi-officially, even if he used a pseudonym. It wasn't glossing the way I gloss my own books, that is to say, right marginalia. Or I can remember back in graduate school when I lent a copy of a book to a friend of mine, and then when he returned it, I discovered that he had written his own notes in the margin, and I wrote a parody paper of about 2 or 3 pages on the thought of my friend as discerned through the glosses. But those sorts of glosses, I mean, I've often been tempted when I read Supreme Court decisions, even in US reports owned by the UT Library, to put my gloss in the margin and indicate things like nonsense or legal formalism at its worst or stuff like that. And I guess what holds me back is that that would be transgressive. It's not my property. That's not really what we're supposed to do unless we own the text or in some ways have been given the power to offer those sorts of commentaries. So his act, I would call, I mean, is it truly transgressive if he, in fact, is allowed to pick the font and what pseudonym he wishes to publish under? Most people couldn't do that, but he could and did, and I found that independently interesting. And then one turns to the content of what he was writing, and that's, I found, obviously very interesting, particularly with regard to the fact that the Wiseman Award is not only about law and literature, but also about justice, because I think what he is commenting on is the propensity of legal formalism to leave humanity and justice behind. And at one point you refer in your paper to the ungainly shuffle of papers between claimants, lawyers, the case office, and the like, and the papers have to be written in legalese. And the more they're written in legalese, the more they take you away from realizing the human issues that are at stake. So I will say that there were 2 associations I had when reading the paper this time around. One, as I say, is to Kafka, because it does seem that one way of reading his commentary is that this is a Kafkaesque process by which the victims of unimaginable discrimination and oppression nonetheless must use the instruments of a more enlightened state, to be sure, but it's still a state that, as you indicate, is quite ambivalent about restitution. It seems to distinguish quite sharply between the deserving and the undeserving claimants. And as you indicate, and as he indicates, these distinctions seem quite bizarre, indeed, even Kafkaesque. in the lines that are drawn. And then that reminded me of another lawyer, a woman named Sarah Fabian, who became briefly infamous because as a lawyer for the Department of Justice, I think in 2017 or 2018, she solemnly argued before the Ninth Circuit Court of Appeals in San Francisco that it did not constitute inhumane treatment to deny children who were detained by the United States as part of the border control, to deprive them of soap and toothpaste and toothbrushes. Now, one of the articles explained that she was forced to make this argument because of certain legal technicalities and trying to attack a consent decree from several years before, but she made the argument. It went viral on YouTube, and she was shamed for acting like a lawyer in a Kafkaesque system, which is certainly what the American immigration system was and is, even under the Biden administration in many ways, but certainly under the Trump administration. So, I found this a fascinating story on the surface, wanting to know more about Dr. Schwarz. I was intrigued, for example, that not only had he moved back to Germany from Israel, but he ends up moving from Germany to Switzerland. And, I'm curious, why did he decide, after all, that he was uncomfortable as a German Jew, though I'm not exactly sure why Switzerland would necessarily have been a more warming environment. Why not move back to Israel? So there are those details that I would like to know more, should you decide to expand this from being simply a chapter of your thesis into a full-fledged, novella style short book. But then, as I say, I do find myself interested by what it says that he did have the legal ability, if you will, to take control in some sense of the actual text of these decisions and to leave his glosses for others to read. And then simply to be curious about any literary influences on him. Say, had he become familiar enough with the Talmud to find this particular format attractive? And I'm curious, given when he was born and when he was educated, had he read Kafka? And did he realize that there was something very amiss about the way lawyers think and about the legal bureaucratic process that is in tension with the human realities of whoever is caught up within it, whether it's Joseph K. or the children who were denied compensation by at least one court, perhaps even the final court. Or I was particularly fascinated with the decision that the 9-year-old who had worn a yellow star wasn't entitled to compensation because, after all, the law didn't require wearing a yellow star until you were 10. So this was a voluntary activity by the 9-year-old. And as it is glossed, that is just insane. But then you try to put yourself into the minds of presumably, quote, good lawyers, unquote, who find this sort of thinking altogether reasonable. So I really do think this is a terrific paper. I think my initial instinct was right to think that this was best of show. And I was delighted to have the occasion to read it in greater depth and to think about it in greater depth than originally. So thank you.
Thank you, Sandy. Just a minute. Can you hear me? Because I'm getting weird messages. Okay, great. Thank you very much, Sandy. Let me just inform everybody, including guests, of our procedure. I think I'll actually ask Laura first whether she would like to react to anything that Sandy said, and then we'll open it up for discussion. And the way it works, if you want to speak or have a question, raise your digital hand and I'll keep a queue of questions or comments and I'll be calling on you. So hopefully you know how to raise your Zoom digital hand. If you don't, raise your real hand and hopefully I'll see you, or you can send me something via the chat. But Laura, would you like to react first? Please go ahead.
Thank you. Thank you so much, Sandy, for that response. I just grabbed this book off my shelf. So this is Schwarz's autobiography that he's written. It's called Späte Frucht, so late fruit, sort of a report from unstable years. It hasn't been translated into English yet, but it does give you a little bit of an insight into some of those thought processes that you were interested in. And so thank you so much for your thoughtful, but also really interesting commentary that linked some of these processes to also what's still happening now and today. So just on Schwarz, it's really interesting. I think he was more of a secular Jew. And he had a lot of trouble finding work as a lawyer. So after he qualified in Germany, he actually went to France for a while to try to work as a lawyer, and that didn't work out either. And he was having difficulty finding work. So when he emigrated and got out of Berlin and got out of Germany and went to Israel, he actually then qualified as an Israeli lawyer as well, or at that time in Palestine. But then didn't get a job there either. So it's sort of interesting. His autobiography is sort of really talking about how he was a failure in some ways in his profession, which I find sort of fascinating reflection back on what he then became, because he originally went back to Germany and went to Munich and was involved with some of the negotiations at that time between trying to work out some sort of reparation agreement between states at that point. And then he decided to move to Berlin and open up this practice. And the restitution law practice that he had was incredibly successful. So he became quite wealthy through this practice. And so he writes about how he would drive around Berlin in his he had a Volkswagen car, which in the 1950s, was quite astounding and kind of would look at kind of the city at that time. And so he ended up having these incredible people that would come into his office as well at that time. So he talks about, the philosopher Ernst Bloch coming in, and famous theatre directors and other people at that time coming in to speak to him about their restitution claims. And so he talks about how suddenly he was kind of meeting and in this different milieu of people that he hadn't actually had contact with before. So it's such a fascinating story. He doesn't talk a lot about his sort of cultural influences or what he was reading or what he was doing, but I'd have to read it again closely to pick up on some of those aspects. But he basically decides in 1967 that he's had enough of being a lawyer and that he just gives up and says, I just can't do this anymore. I don't want to continue the practice, and sort of completely uproots his life and goes to Switzerland with his wife at the time. So I think there's more to this story to be told, the autobiography needs a closer read by me, but also perhaps a translation so that other people can read his words for themselves. And yeah, absolutely. I think that there's a moment here that is captured in these glosses that reflects a lot about him as a person, but also about Berlin and the restitution program at that time. So thanks for those comments.
Thank you, Laura. So the floor is now open to anyone who has a question or comments. And again, either raise your Zoom hand or chat. Is it, I'm sorry if I'm mispronouncing the name. Is it Nicole? Go ahead.
Let me just unmute. I was thinking, Laura, during your paper of someone I knew as a graduate student in the UK who shared many of Zipporah's talents. He was also extremely literary, as well as being a superb lawyer and someone very interested in social justice. And that was a man named Herbert Hart, who wrote The Concept of Law. And it was someone, Zipporah greatly admired Herbert. And it was one of the things that led us to become good friends, was that association. But I was thinking about an anecdote from Herbert's career when Professor Levinson was talking about Kafka. Herbert engaged in a debate over legalizing homosexuality in Britain. It had been illegal between men, not between women, because the Queen at the time, Victoria, couldn't imagine between women, but between men, it had been illegal. And so Herbert joined in a debate, I think it was on the BBC, with a man named Lord Devlin, who was a conservative law lord who opposed legalization. And after the debate was over and it was agreed that Herbert had won, and indeed it became, these practices very happily became entirely legal afterwards. But Devlin was asked by the BBC what he thought of Herbert's remarks, of the legal side of Herbert's remarks. And he said, Hart has a first-class legal mind marred by compassion. And so I thought that was very much what you were speaking about, in the Kafkaesque nature of the law at times, that it is the compassion that shines through, and it's the human side, which you bring out so beautifully. And I thought that not only Zipporah, but Herbert also would have admired your paper. So thank you very much.
Thank you so much, Nicole. That's really kind. And a really fascinating connection across as well, to kind of bring in that thread of people across times and across places that are really working in a common way and thinking about these questions really deeply and thoughtfully. So thank you.
Oh, you're very welcome. I think it is a question of common sensibilities, which we recognize in these rare people.
Yeah.
I think I will go next. Just a moment. Here we go. Actually, I think, Laura, thank you for the paper and for presenting it. I think there are too many things I would like to ask you, so let me try to choose just one, more or less, I guess. Could you tell us a little bit about sort of the other actors involved in this act of communication, right? So we heard about Schwarz. So obviously, is there an intermediary? Is there an editor? Who publishes that journal? Who decides, if at all, what goes in and what doesn't go in? Who's the audience in real time? Any idea what was the purpose of speaking to that audience? Any idea whether it was effective or not? And I guess historically, for I guess the onlookers, whoever the audience is, what exactly are we to take from those messages?
Thank you, Oren. There's questions that I also worried about and thought about and tried to work out myself, because I think obviously any part of thinking about a text is trying to work out what was the intended audience at the time and who was it actually written for. It appears that Schwarz himself was one of the editors of the journal, so that explains why he kind of had this freedom to put these glosses in the journal. But you have to note that, so the journal started and was quite, as I look at it, quite a straightforward kind of thing with quite black letter summaries of this happened in this case and this happened in that case. And then a few years on, they kind of transformed it into this space where people would also write essays and there would be more commentary. So the glosses are kind of appearing in this context of other people also providing opinions, but they stand out from those other forms of commentary because they're a lot more personal or kind of a lot more emotive. They have different style in terms of bringing in literary forms, and they kind of really step away from that neutral mode of argumentation that is in everything else in the journal. But interestingly, other people also started to write glosses too. So there are a few other glosses from different authors that at times were also under pseudonyms, and at times also they included their real names. And at times, there's one instance actually in the journal where a judge actually responds to one of the glosses. So he writes a response to the gloss that is then printed in the journal as well. So from that instance, I can think, right, well, at least this was being read. and a profile of Schwarz that was written after his death by a fellow lawyer. But in the profile, this other lawyer writes, well, you know, we picked up the Decisions of Restitution Law journal, and the first thing we would thumb through to look at would be the glosses to see, you know, what people are saying. So I feel like because of this form, he actually got more of a readership for what he was trying to say, because it was written in an engaging kind of style that people then picked up and read. So it probably got more of an audience, I think, than just writing another essay on, you know, section whatever of the restitution legislation, etc., etc. So I feel like the form is kind of integral to actually having a readership at that time. But I mean, you have to think about, I'm talking about kind of a really small group of people that were working in this area of law at the time. You know, there's a lot of interaction between the bureaucracy and the lawyers, and it was a legislative process that was also kind of being, you know, developed in real time. So the laws were being revised. There was a lot of kind of controversy in the German society at that time as to the amount of restitution, the way it should be done. So there's a lot of kind of outside controversy going on, but inside this kind of bubble of interaction between bureaucracy, lawyers, and legislature, nothing that sort of doesn't break through either. So there are lots of course, in any kind of legal situation, there are all sorts of different strata of relationships, and so I think he had an audience where it mattered at some point, because the people who were looking at these glosses hopefully were actually then thinking about how they were making the decisions, but it's impossible to tell. And, you know, the title of his book also makes me think, well, he's kind of at that point reached a point where he thought, well, I just have to give up now. I've done everything that I can at this point. And perhaps it was all kind of spoken into the wind. Yeah.
Thank you. I have Jens Damian and then Sandy. Jens.
Hey, so I really enjoyed your presentation. If there's some violin in the background, that's my daughter. I apologize. I have a question and a comment, right? So the comment is, I think it's fair to assume that people in the area would all read that journal. You know, there's a long tradition in Germany for very, very specialized journals, right, that are targeted. But then the good thing is everybody who's working in that area, you know, it's pretty much required reading, right? And so that certainly added to the sort of the effectiveness and the usefulness of the comments. Now, what I'm sort of wondering is, so you have an area where there's tremendous hardship, right? I mean, sort of, cruelty, hardship, and where certain features of the justice system are made visible in a particularly striking way, right? And you also have a justice system which at the time was in a somewhat delicate state, right? In the sense that, so yes, there were working courts, but a lot of these judges had biographies that you really didn't want to look at, overly closely, right? So you could imagine where judges to some extent hid behind formalism, in the sense that, it sort of prevented them from being forced to address issues that would sort of perhaps, inflame certain conflicts that are sort of present on the bench anyway, right, to put it delicately. And but some of these features, right, they're not germane to restitution law, right? So the human hardship part, right, you could imagine that existing in certain other scenarios whenever compensation is at stake, maybe insurance law even, right? You have the bureaucracy angle of German courts, which again, unfortunately, right, not entirely limited to this particular time or era. The Kafkaesque part, I see that as well. Again, particularly stunning here, not necessarily limited to it, but there are certain features that are limited to this, right? So there's the feature that, again, I think the judiciary had trouble because of its own troubled history addressing this. And my question is, how much of your analysis of this topic is germane to this particular historical setting, and how much is just sort of reflects broader difficulties that the justice system has dealing with, issues involving tremendous tragedy? Am I being clear?
Yeah. Look, I mean, I think to respond is to just also say, I think, both things are right at the same time. I mean, I think, obviously, and what I've tried to do at some, in this work and to try to put this back into a time and a place and to kind of assess and think about how Schwarz was writing as a German Jewish lawyer at that time, working with colleagues who had gone through nominal denazification processes, working with a court system that, as you say, was also being rebuilt and kind of put together again, and was also in flux. And as you say, I think that's an interesting comment in terms of hiding behind formalism, in terms of avoiding the controversy of the context. I think that's an interesting way to think about it. But I think, of course, this has resonances then beyond, once you do that work, this has then resonances, as we saw in Professor Levinson's commentary, beyond the scope of Berlin and Germany in the 1950s, 1960s, 1970s. I mean, this concept of justice beyond the legal strict interpretations of a legislative provision, this idea, as you say, of trying to work out compensation, this idea of going through, as Professor Levinson was saying, so reinscribing the same technologies that oppressed and murdered and tortured people in terms of, an incredibly kind of efficient bureaucratic system. You have to enter that again in a different form to actually get compensation for those harms. It sort of reinscribes that trauma again. These are all issues, I think, that come up when you try to think about how to set up some sort of compensation or reparations or restitution type scheme. And so I think there are lessons here to think about in terms of what happens when you do that, and how do you hold on to perhaps the human dimension when you are thinking through really big questions of injustice and how to actually work out a way of restituting that in the present day. So absolutely time and a place, but has these different resonances and lessons out, I think, for the present day that need to be be heard too.
I now have Sandy Levinson, Karen, and Willie Fulber.
Why don't you take Karen and Willie first, and then if there's time.
Great, thank you, Sandy. Karen.
Great, thank you so much, Laura. And I, as you know, very much enjoyed the paper, and I also really enjoyed you presenting it, and it was great. I kind of wanted to say, maybe you could put some of those slides into the paper because it was very useful. I had an image, it was a little bit different from what you presented of what those texts look like. I had two questions, and the first one was actually the one that Jens just asked. So maybe I'll just push a little bit to say, because I wondered, and this was really from Sandy's first comment, did we want to accept that it was generally a critique of formalism, or it was a critique of this particular type of formalism? And to a certain extent, even if he's writing outside of it, as you said, he's trying to affect a more formalistic response. And so I was thinking of Marty Koskinemi and arguments about neo-formalism, and maybe just, do we want to concede that that's all formalism can do? The second question is really, you might not know the answer to this. I don't know the answer, and I'd just be really curious to think about it. But do you have any sense of how these restitution cases were thought about in relation to also the idea of criminal prosecutions at the time? And I ask that, well, in part because I work a lot on international criminal law and criminal law in the broader human rights context. And because today, so much of the focus is on criminal prosecution, including in Germany. Not that the restitution cases have gone away, but I think, like, I didn't know much about these cases, practically nothing from this period. So I found it really useful to read about them and just wonder if there was overlap, if it was at the time when criminal prosecutions weren't happening, there were more likely to be restitution cases, etc.
Yeah, I mean, thank you, Karen. Just on that point, I mean, I was really struck by just starting to research in this area. I mean, everybody knows about the Nuremberg Trials. You know, they're just such a touchstone for people working in international law and international criminal law. Even the Auschwitz trials and the criminal kind of forms of taking responsibility that happened. It is really interesting how these cases interacted. I mean, obviously you have to remember these are kind of getting to the court because people are disputing the claims. But they're really, it's my impression that at the time they were also not really well known or kind of understood as an area of law in a German law university sense, or internationally. So there's one international lawyer writes a review of Schwarz's book, and when he moves to Switzerland in 1967, he actually works together with the Ministry of Finance to release a 7-volume work. They edit it and get contributions from people on the restitution regime at that time. And that gets reviewed in an international law journal. But that mention is kind of the only kind of thing that I've found that other people outside of this are even engaging with this topic. So even now, there are 1 or 2 people who have written on this. And in Germany, it's sort of treated as a historical sort of thing that the historians look at rather than the lawyers or people working in a law school. So yes, there's this really different approach, I think, to these kind of sort of claims compared to the criminal, the way, or the I don't know, the attention that gets given to the more perhaps tangible criminal ways of taking responsibility than these other ways of paying restitution and compensation. But that being said, I mean, these laws have gone through so many permutations now. I mean, they were also highly criticized, especially say in the 1980s. I mean, the laws left out a whole raft of people that weren't eligible to get any sort of compensation, you know, including people who were persecuted on the basis of their identities, so like the Sinti and Roma people, or people who were persecuted in terms of political orientation, like communists and other people. You know, people who were persecuted on the basis of their sexual orientation didn't get any kind of compensation right up into kind of the 1980s, where different things changed in the legislation. So I'm not advocating that we look back at this time and think, wow, this is a sort of a shining light of restitution time, legislation. It's sort of something, though, that I think needs further study. Absolutely. I mean, now you talk about restitution in Germany or restitution after the Holocaust, lots of people think about the restitution of artworks, and that gains a lot of kind of attention, and there's films being made about that. There are lawsuits in the US, I know, ongoing, but also sort of throughout even the museum system now, this sense of provenance and returning of stolen goods has become kind of has this other resonance now that's really infiltrated all sorts of collecting practices and other forms of restitution that need to happen. So it's a really evolving space. I think that I would advocate going back and thinking about what happened to this, kind of see that in its context too. Thank you.
Willie Forbes.
I wanted to echo a text I got at the end of your talk, and my colleague and friend, our colleague and friend Jordan Steicher said, what a truly worthy recipient of the Zipporah Wiseman Award you are. And partly just because of the amazing sort of wedding of the sort of form and substance. It was really a lovely, sort of elegant presentation. So thank you so much. It sort of had its own kind of literary sort of brightness and depth. So thank you. A scholar at Tel Aviv, whom you may know, named Leora Bilski, is working on the theme of restitution and chronicling efforts. She's worked on many aspects of it, but without, just to sort of be as terse as possible, she's looking at the ways in which there were both the sort of dominant famous players who negotiated the more collective forms of restitution and reparations and crafted and reworked legal the legal concepts afoot. And it's striking both how, from where Schwarz sat in that moment, it seemed the enormity of what was sort of trying to be compensated, repaired, in some ways the way he kept the rage and anguish under control was quite striking. Anyway, because he's sort of working in this moment, or at least in this context where thinking large about repair was sort of seen beyond the horizon. And yet there obviously was afoot also collective ones in the polity, ones that Israel was bearing down on. So that the history of how reparations becomes sort of a much larger, however inadequate, project compared to the world in which he's having to sort of push is one striking thing. But the other thing that Leora's work made me think of is that she writes about the main players and then a couple other players, a woman in particular whose name now escapes me, someone here may remember, a woman who was sort of younger lieutenant lawyer, sort of in the second tier, who imagined yet a different, more capacious, more culturally sensitive vision of what restitution could mean. But both the main players and the dissenting voices within that milieu were plumbing what restitution means. In other words, they were saying there is sort of kind of a sort of moral resources and even imaginative resources in the law itself, not simply by sort of saying, let me tell you the human story, let me sort of the move that Sandy was talking about, the sort of pushing against the legalism or the legal formalism. I think another passageway that those lawyers were working through was, let's look afresh at the legal terms for their suppressed moral content. And I wonder if Schwarz ever did any of that.
Thank you so much for the kind words, but also this comment. I haven't heard of Leora Bilski's work, so that's a really good name to follow up and to read further on. You know, I think it's that weird thing of trying to deal with the minutiae of the cases. And so it's that sense of trying to capture, as we've been talking about, the stories of the everyday and then that experience. And, you know, as we were talking about, trying to translate that into legalese and get that into the forms that can be filled out and the categories that apply. But I feel like, you know, in doing so and in doing the glosses, Schwarz was also, you're right, thinking about what does it mean to actually compensate for this. And, you know, he's very strident in terms of the timing and other things. It was in terms of not just the kind of the bureaucracy and the ungainly shuffle of the papers, but just that, what does it mean if you die before you actually get this kind of recognition? And that's important in terms of a material sense of some people didn't have money to live on, but just in terms of that, the way that this could be a form of recognition for you as a victim, or just as a way of saying this happened to you. And so he really touches on this question of time. You know, what does it mean to just hand over an object to the heirs of an heir? You know, that's not in the spirit of actual real restitution. So I think you're right. It's that balance of kind of trying to think about, okay, well, how do I fit this story into the legal categories? But also, how do I, in the glosses, it's this broader question of how do we conduct this process in a way that means that it's actually meaningful to the people involved, and it reaches them before they actually die, and it makes not only material difference, but kind of an emotional and a different form of recognition in that way. So I think it's all tied up, and it's all tied up in together. And, you know, some of these stories need further telling as well, I think. I mean, I can't touch on them, and I'm, you know, reproducing them in my own text for my own purposes. And I've reflected a lot on that in terms of, you know, Schwarz uses these stories in a particular way to argue a particular point about the system, or to rail against certain things, but he's sort of taking up these people's stories to do that. And I've also taken up their stories in some ways to do this paper and to do this research. So that's something I also think about and try to acknowledge, and try to acknowledge that, you know, these are commentary on top of commentary, but at its core is something really awful and kind of unrecognizable too.
Thank you. Sandy, I think we're out of time, unless you want to go for a really, really quick comment or question.
Okay, I'll try and make it very quick.
Okay.
I am curious about the form of the restitution court because if it's like typical German courts of the 50s, there were no dissents and no concurrences. And I think that encourages a former style, whereas in the US system, you often get the equivalent of glosses in concurrences or dissents. So I'm just curious if there was one and only one opinion that would inevitably adopt a formal style.
Thank you for the question. And to be honest, I'm not 100% sure, but in my reading of some of these cases, it is always a unanimous decision. So the judges are always listed at the end. There's no dissent at all that I've come across, but that may be just my closed reading in a particular space. So I don't want to pronounce that as the way it is at that time. But I think you're right. I mean, I think just thinking broadly about the role of the dissent and the dissenting judgment. I mean, as you were saying before about Schwarz's power in order to write, I mean, obviously a dissenting judgment has that different layer of power and authority that comes with the court and pronouncing the dissent. But you're right, it's that extra form of commentary that can critique and be sit with and not agree with the majority. So I'm sorry, I don't know the definitive answer to your question at that time, but it is my impression that everything was put through as a majority decision.
Okay, I think we are at time. So Laura, again, thank you so much for the fascinating paper and for the presentation. Thank you. And thank you, everybody, locals and guests. Thank you for coming. Thank you for sharing your thoughts. Thanks.
Thank you so much for having me today.
Thanks. Okay, so session ended, I guess. Laura, by the way, I think Willie made a good point. You really want to look at Leora Bielski's work. You'll find it very interesting, I think. Both the themes, but she's very much writing in the mode of law and literature. I think you'll find it interesting.
Yeah, great. That's really useful. Thank you so much.
So you got the name, Leora Bielski?
Yes.
Okay.
Yeah.
It's in the chat, but I know there was a lot going on in the chat.
Yeah.
Sorry, I haven't looked at the chat.
Yeah.
Yeah, so it's the last one.
Can you save it, Oren? I can't save the chat.
I don't know how to save it.
I've clicked on it. It's okay. I've got it up.
Okay.
Thank you so much.
Sure.
That was great, Laura. Really appreciate all the work you put into that and connecting it to Zipporah's work too. So.
All right. Yeah, thank you. I mean, I feel like I'm really late to the party and I really would have